Good evening. This is the July 16th, 2013 Constitution Meetup in Austin, Texas, and I'm Jon Roland. The topic for this evening is titled Ratchet of Rot. I chose that alliterative title to encompass the notion of a one-way descent into degradation, and in particular to focus on how the Supreme Court over the course of 2 centuries deviated from the Constitution on the interpretation of 2 main clauses of the Constitution. The first is the Commerce Clause, which delegates to Congress the authority to regulate commerce among the states. The second is the Necessary and Proper Clause, which provided for Congress to have the powers that are necessary and proper for carrying into execution the other powers, the explicit powers. And unfortunately, those words have been given a broader interpretation than was intended by the framers. On my website, constitution.org, and on my blog, constitutionalism.blogspot.com, I have a number of articles that examine the problems arising from this misinterpretation and the arguments and evidence for why the clauses should not be interpreted in that way. But this evening, I'm going to focus on the line of Supreme Court precedents that led to where we are today. There are 44 main Supreme Court precedents. There are many more cases than that, but most of those others cite one of the or more of these 44 cases. So if one were to overturn these 44 cases, and in fact you wouldn't need to overturn all of them, if you overturn the first few, the rest would fall, because the later ones are based on the earlier ones. But for the sake of completeness, if one were to propose amendments to the Constitution to overturn these bad precedents, which are about the only way they are going to get overturned, then it would be necessary to unravel them fairly specifically. And the way to word such an amendment is not at all obvious. It requires a good deal of analysis and thought, and I hope to assemble teams of experts to work out the wording for how to do that. In the meantime, I have proposed my own wording. On constitution.org, you will find a link to constitutional amendments, and among the clarifying amendments are amendments to clarify the wording of the Commerce and Necessary and Proper clauses to bring them into compliance with what was clearly understood by the framers. Now, the first case to make a major departure on this subject was McCulloch v. Maryland in 1819. Now, this was actually a tax case in a way. The First National Bank, which was headquartered and chartered in Washington, D.C., wanted to open a branch in other states, and in particular in Maryland. Well, it did that. Maryland didn't object to it having a branch in Maryland, but it wanted to tax it. In fact, it wanted to tax it more than it would be taxing its own banks, because it was trying to favor its own Maryland banks in competition with the First National Bank. So it was discriminatory taxation, but the National Bank essentially sued with a guy named McCullough representing it, and the Supreme Court held, with Justice John Marshall writing the opinion, that the National Bank was tax exempt because it was a federal agency. Now, considering that it was a private bank, that was a controversial decision. What the First National Bank was a private bank that happened to handle most of the funds of the federal government under contract. But it also handled other people's funds. So it was not simply an instrumentality of the federal government. But John Marshall said it was, and therefore it couldn't be taxed. And, but one of the problems with this case is that in the opinion, Marshall went into a fairly expansive discourse on the necessary and proper clause and said that necessary and proper only meant convenient for the purposes of Congress, which was, and he argued that was a common meaning in, let's say, street English, the language of ordinary, everyday people. Well, of course, the problem is that the Constitution is not written in street English, it's written in legal English. And the authorities for its terminology are not people on the streets, it's the great legal scholars like Blackstone and Cook and others who defined the legal language in which the Constitution was written. But the problem, that opinion opened the door toward a very expansive interpretation of the necessary and proper clause, which has continued to plague us to this day. And McCullough v. Maryland is still cited as the foundation for many, many other cases. Most recently, NFIB v. Sebelius, the lawsuit over the constitutionality of the Health Care Act, in which the court held correctly that the necessary and proper clause did not authorize the individual mandate, but then Justice Roberts said, well, but it was merely a tax, and in particular a indirect tax, and therefore it did not have to be apportioned. Now, considering that it was a tax on not doing something, it opened up the floodgates for taxation on doing nothing, which, if carried to its logical conclusion, would pretty much do in both federal and state constitutions. Because once you can tax not doing something, you can tax and therefore destroy not doing anything. So that's a very dangerous precedent, which has been discussed in earlier meetings. But it does illustrate that where the opinion in McCullough v. Maryland has taken us, well, through a number of steps. The next one, shortly thereafter, 1824, was Gibbons v. Ogden. Now, this was the first case which defined commerce, or tried to. And the original meaning of commerce, which we can obtain from the 1771 edition of the very first edition of the Encyclopedia Britannica, was trade in tangible commodities through the intermediation of a merchant. It did not include services. It did not include the people engaged in the trade. It did not include anything but the articles of commerce themselves. And they had to be tangible, something you could hold and touch. So what this opinion did is it expanded the definition to include navigation and commercial intercourse. In other words, the activity of trading, including moving things around. Now, it is part of the meaning of commerce that it has to be moved from a seller in one state to a buyer in another, or from a seller in another country to a buyer in a state, but the motion itself is not the commerce. Only the articles are commerce. And if you are simply moving things that are not being sold, like people or personal goods while you're traveling, that's not commerce. But, again, it also expanded the definition of regulate to be considered, to say that it was plenary. Well, there's no such thing as a plenary power in the Constitution. To be a plenary power means the power to do absolutely anything on the subject. And all powers delegated in the Constitution have to be reasonable for a reasonable public purpose. You can't just say that because there's a power to regulate commerce, therefore there's a power to prohibit all commerce whatsoever by everybody. That would not be a reasonable exercise of the power, and it would be therefore unconstitutional, even though the language of the delegation of authority would seem to allow that to be an interpretation. The next one was Groves v. Slaughter. And this was a correct decision, because it held that the power to regulate commerce did not imply the power to prohibit it. In other words, you could restrict some modalities of articles of commerce, but not all modalities. There always had to be some form of the item that would be permitted to be traded. And in Gilman v. Philadelphia, it extended jurisdiction under the Commerce Clause to all the navigable waters of the United States, which are accessible from a state other than those in which they lie, and this includes the power to keep them open and free of any obstruction of their navigation imposed by the states or otherwise, to remove such obstructions when they exist, and to provide by such sanctions as they may deem proper against the occurrence of the evil and the punishment of offenders. This is actually the first Supreme Court decision, again from Marshall, which opened the door to criminal penalties for the obstruction or the impediment of commerce. And of course later, this also opened the doors to very broad expansion of the idea of navigable waters, so that it now includes things like duck ponds, which don't border on any state. So it's, again, you can see how the jurisdiction of clauses of the Constitution are allowed to creep by successive Supreme Court constructions. Now in Paul v. Virginia, it held that insurance transactions carried on across state lines are not interstate commerce. That was a correct decision, but it was later overturned by United States versus Southeastern Underwriters Association in 1944. So from 1869 to 1944, it was unconstitutional to try to regulate insurance transactions across state lines. And it was after 1944 that interstate regulation of insurance came into being. But it was not constitutional, considered constitutional before. I would say it's still unconstitutional. Now, Reading Railroad versus Pennsylvania, also known as the state freight tax case, held that the first case was the first case to strike down a state law solely on Commerce Clause grounds. And the argument was that the commerce power was preemptive over the states so that they could not then pass laws which would interfere with interstate commerce. And the argument was that Pennsylvania, their freight tax law was an impediment to interstate commerce and therefore could not be allowed. The next one, U.S. v. Kagama in 1886. Now we're moving along pretty fast here. You know, we're almost a century from the founding. It rejected the Commerce Clause as a basis for a congressional enactment of a system of criminal law for Indians living on reservations. In other words, it held that the Commerce Clause did not authorize criminal penalties correctly. However, it also sustained the act on the ground that the federal government had the obligation and thus the power to protect the weak, independent people. Now, where does it get that from? Well, it gets it from nowhere. Okay, they're simply inventing a non-existent clause of the Constitution. Just because it has an obligation, some moral obligation, to protect a weak, independent people, doesn't mean they have the constitutional authority to enact criminal legislation. Now, in Kidd v. Pearson in 1888, it held that manufacturing, even when the product was moving interstate commerce, is not reachable under the Commerce Clause. In other words, making something is not commerce, so it's not subject to regulation. But that was later overturned by NLRB versus Jones and Laughlin Steel Corporation in 1937. That was one of these switch in time saves 9 cases where the Supreme Court, under pressure from the Roosevelt administration, flipped and started approving New Deal legislation. 1937 was the key year for that, and this was one of the key decisions. And so the court overturned its own previous correct precedent in order to adopt an incorrect precedent so that the New Deal could go forward. Then in the U.S. v. Knight, the Sugar Trust case, it was about the Sherman Antitrust Act, but didn't rule on its constitutionality. But a decision on the construction of the act impaired its effectiveness. So basically, it maintained that production is always local and under the exclusive domain of the states, and that commerce among the states does not begin until goods commence their final movement from their state of origin to that of their destination. So commerce only extends to activity with a direct effect on interstate commerce. But it still includes activity. So it's already gotten away from original meaning. Now, in re Collock, 1897, sustained a criminal conviction for violation of a regulation under an act to regulate commerce, which was ruled merely a matter of detail. So all of a sudden we have a criminal conviction and it's considered just a matter of detail. And that's in a very short statement, by the way. It was almost no real discussion of the merits of the case. dashed it off. Then under Addison Pipe and Steel v. U.S., it upheld the Sherman Antitrust Act of 1890 to break up industrial combinations to divide territory among themselves. In other words, now this was not a criminal penalty involved here. It was simply a civil penalty. But it was recognizing and the power which Congress had not been granted under the Constitution to break up monopolies or large organizations, which we may consider a good idea, but the framers didn't think of it. Now, in Reed v. Colorado in 1902, now we're finally getting into the 20th century, it upheld the first statute passed in 1884 to impose criminal penalties for a violation of a regulation of interstate commerce, which prohibited transportation of diseased livestock across a state line. This overturned the understanding that commerce power did not include or imply penal power. That was the key pivotal decision that opened the floodgates for penal powers based upon the Commerce Clause. Now, in Champion v. Ames in 1903, it extended the power to regulate to include the power to prohibit. Remember the earlier case that said that that was unconstitutional. Then in 1904, McCrae v. U.S., it held that a tax may be imposed for regulatory or prohibitory purposes rather than to raise revenue. The original understanding always was that the power to tax was only to raise revenue. It might have an incidental regulatory effect, but it would be considered unconstitutional to impose a tax just to regulate. And if a tax were so large that it would actually bring in less revenue than if it were at a lower rate, that would be unconstitutional as well. It had to maximize revenue. It could not be at a rate so high as to that the revenue would start going down again. Now, 1905, Swift and Company of the U.S. Business transactions and the like which are antecedent to or subsequent to a move across state lines are conceived to be part of an integrated commercial whole and therefore subject to the reach of the commerce power. Okay, now we're well before the New Deal here, but you can see the jurisdiction creep occurring already at this point. Now as commerce is not just the articles of commerce, it's the whole activity, everything that is connected to it. It was later came to be called the stream of commerce. Then Illinois Central Railroad versus McHenry, 1906, upheld criminal penalties for violation of regulations of interstate commerce. The first such penalties, well, again, this was actually related to the earlier case, but it sustained it more clearly. But it also held that federal quarantine regulations of this sort have become constitutionally inapplicable to intrastate shipments of livestock on the ground that federal authority extends only to foreign and interstate commerce. So that part of it was correct. Now under Lowy, so you see the course of these opinions is not all in one direction. Sometimes there's a backward movement. So just like a ratchet, you know, it moves forward, but then it jumps back before it moves forward again. Well, that's kind of what we see here. That's why the topic is called Ratchet of Rot. In Lowy v. Lawler, in 1908, it's held that combinations of employees engaged in such intrastate activities of manufacturing, mining, building, construction, and the distribution of poultry were subjected to the penalties of the Sherman Act because of the intended effect of their activities on interstate commerce. Now it's not just necessary that they be commerce, that they are intended to be commerce. Then in Houston v. Texas Railway v. U.S., 1914, it may be necessary to regulate purely interstate activities in order that the regulation of interstate activities might be fully effectuated. All right, now we're reaching into the states. This was 1914. We're not at the New Deal yet. Okay, now, at Caminetti v. U.S., 1917, it upheld a statute forbidding transportation of a female across state line for non-commercial sexual purposes to enforce majority conceptions of morality as within the scope of the Commerce Clause. Now Commerce is getting involved in morality, prohibiting prostitution, essentially, across state lines. But it's considered non-commercial. They don't want to call it commerce, and yet they're extending the Commerce Clause to it anyway. Now, in 1818, Hammer v. Dagenhart, it held that Congress is not empowered to ban from the channels of interstate commerce goods made with child labor, since Congress's power was to prescribe the rule by which commerce was to be carried on and not to prohibit it, except with regard to those things the character of which, diseased cattle lottery tickets, was inherently evil. All right, that's basically a correct decision. But in 1941, it was overturned by United States v. Darby. So we see how the ratchet swings up forward and swings back, but keeps moving overall in the same direction. Now, in U.S. v. Ferger, Congress has criminal jurisdiction over fraud which obstructs or influences interstate commerce. There's no authority in the Constitution to penalize anyone for committing fraud. But it says here that it does have such jurisdiction if it obstructs or influences interstate commerce. So we're taking what amounts to a common law crime, for which there's no constitutional authority to pass statutes to make it a crime, and we're making it a crime by claiming that it obstructs or influences interstate commerce. Now, of course, influences is a very vague term. Everything influences everything else. So the floodgates are open here. In U.S. v. Simpson in 1920, it further expanded the definition of interstate commerce to include every species of communication, every species of transmission of intelligence, whether for commercial purposes or otherwise. In other words, now we're bringing in communications, speech, press. Then, in 1922, Stafford v. Wallace upheld the Packers and Stockyards Act, whereby the business of the commission men and livestock dealers in the chief stockyards of the country was brought under national supervision. Whatever amounts to more or less constant practice and threatens to obstruct or unduly to burden the freedom of interstate commerce is within the regulatory power of commerce under the Commerce Clause. And this was based in turn upon the rather cursory opinion of Swift v. United States. Then in Brooks v. U.S., 1935, it struck down correctly the provisions of the National Industrial Recovery Act. It allowed legislative standards test to allow limited delegation of legislative authority to an executive agency, but held that once items in commerce came to rest, interstate commerce in them ceases, and the effect on interstate commerce had to be direct to subject it to regulation under the Commerce Clause. This was one of the big decisions that thwarted the New Deal, and that Roosevelt had to get overturned. Well, so Schechter Poultry is considered one of the key decisions, and it was in fact later overturned. In U.S. v. Butler in 1936, the court held that the welfare clause is a broad grant of power, rather than only a restriction on the power to tax, which directly defies the grammar of that clause. But it struck down the Agricultural Adjustment Act of 1933 as an attempt to regulate production, subject only to be prohibited to the United States by the 10th Amendment. So this was a slightly complex case. Again, it was before the big turnaround in 1937. But you're beginning to see the court beginning to hedge its bets. Now, in 1938, this was after the switch, U.S. v. Caroline Products. The power to regulate commerce, whether with foreign nations or among the several states, comprises the power to restrain or prohibit it at all times for the welfare of the public, provided only the specific limitations imposed upon Congress's powers as by the Due Process Clause of the Fifth Amendment are not transgressed. Or you can see how Caroline Products is based upon Butler. The court opened the door to Caroline Products by its really dictum on the welfare clause, which it did not need to decide. Then in Sunshine Anthracite versus Adkins, the court held that mining is interstate commerce. Previously, it was not considered to be interstate commerce. Any kind of primary production was not considered commerce. What you dug out of the ground, the lumps of coal, if they're being traded, would be interstate commerce, but not the extraction from the ground. So then in U.S. v. Darby in 1941, it upheld an indictment under the Fair Labor Standards Act, which defined commerce to mean trade, commerce, transportation, transmission, or communication among the several states or from any state to any place outside thereof. Okay? And it prohibited shipment of interstate commerce of goods made by employees whose wages are less than the prescribed minimum. So this was about the first Minimum Wage Act. And so it held to the cumulative effect of many minor transactions with no separate effect on interstate commerce when they are viewed as a class may be sufficient to merit congressional regulation. And it invoked McCullough v. Maryland and Gibbons v. Ogden. Now here is the big case, the big pivotal case, 1942, Wickard v. Filbert. It sustained a criminal prosecution of a farmer under the Agricultural Adjustment Act of 1938 for consuming his own grain, which was subject to price and production controls, as having a, quote, substantial effect, unquote, on interstate commerce because it would overhang the market. And on this one case, most federal criminal legislation is now based. If it were overturned, 95% of all federal criminal prosecutions would be overturned. Then, National Broadcasting Company, VUS, 1943. The court conferred powers on the Federal Communications Commission to license broadcasting stations as a public convenience, interest, and necessity may require. There's no authority in the Constitution to license the airways. You know, it was not thought of. Might be a good idea, but it needs an amendment. There's no authority for it. Next, USB Southeastern Underwriters, it's an insurance company, 1944, further expanded the definition of interstate commerce to include every species of commercial negotiation which will involve sooner or later an act of transportation of persons or things or the flow of services or power across state lines. Again, a much greater widening of the definition of commerce so that the federal government would have power to regulate more stuff. Then in 1945, the Associated Press, the U.S., the court held that the gathering of news by press association and its transmission to client newspapers is interstate commerce. Now, all of a sudden, the Commerce Clause is in conflict with the First Amendment. But guess what? The First Amendment was passed after the Commerce Clause. So how is it that you can overturn the First Amendment by reference to a clause in the original Constitution before the First Amendment was adopted? Now, in 1946, American Light and Power versus the Securities and Exchange Commission, the court upheld the delegation of authority to the Securities and Exchange Commission to prevent unfair or inequitable distribution of voting power among securities holders. Securities are not authorized under the Constitution to be subject to regulation. They're not. They're, at least in the area of services, and perhaps even beyond that, and in association. So this is Congress regulating association and the private rules within associations. Then, in 1964, the Heart of Atlanta Motel was about the 1964 Civil Rights Act, which prohibited racial discrimination in public accommodations as necessary to protect interstate travelers from harm, to prevent such travelers from being deterred in the exercise of interstate traveling, and to prevent them from being burdened. It held essentially that there was no authority under the 14th Amendment to regulate public accommodations, but it didn't look to the 14th Amendment. It found the authority in the Commerce Clause. Then, in 1968, in Katzenbach versus McClung, it held that regulation of a purely interstate activity may be premised on the presence of some object that will or has crossed state line. You only need the presence of some object in the mix somewhere. Doesn't say where, if it's in the room or in the town or in the state. If there's one object in the mix that moved to interstate commerce sometime, then you can regulate everything. Okay, next, Maryland v. Wirtz, 1968. It upheld the enterprise concept of an entire enterprise being subject to Fair Labor Standard Act if any of its activities affected interstate commerce. Well, what enterprise doesn't affect interstate commerce? This was basically a general grab of power to cover everything. Then the next one, Barrett v. U.S., 1976, upheld a conviction for receipt of a firearm upon a mere showing that the gun had sometime previously traveled in interstate commerce. Okay, then the next one, Lewis v. U.S., 1980. A person who has been convicted of a crime in a state court may be convicted of a federal crime for possession of firearms. All right, this is another pivotal case because there is no authority to make it a crime to possess something. It doesn't exist. And yet they're saying that if it has ever moved in interstate commerce, you can make it illegal and make it a crime to possess it. The next one, Odell v. Indiana, 1981, a court may invalidate legislation enacted under the Commerce Clause only if it is clear that there's no rational basis for a congressional finding that the regulated activity affects interstate commerce, or that there's no reasonable connection between the regulatory means selected and the asserted ends. Now, they actually got that one mostly right, but it only opened the door a little bit and not enough. However, it did open it to U.S. v. Lopez in 1995, which held that the prohibition against possessing a firearm in proximity to a school is not authorized as connected to interstate commerce. That was the first real case in 60 years to have overturned a federal criminal statute based upon the Commerce Clause. Now, next one, Karen v. U.S., 1998, even if a state permitted an offender to have a gun he possessed, federal law may use the state's determination that the offender is more dangerous than law-abiding citizens to impose its own felony conviction. Now, what it's doing here is it's making administrative determination that someone is more dangerous than the average citizen. And on the basis of that vague standard, and only an administrative determination, and not a determination by a judicial due process or a hearing with evidence and argument on both sides, it allowed administrators to essentially criminalize the private behavior and possession of objects by citizens. This was an important case, Gonzalez v. Reich. The attorney in this case is a friend of mine, Randy Barnett. In 2005, it held that under the Commerce Clause, Congress may criminalize the production and use of homegrown cannabis, even where states approve its use for medicinal purposes. So Randy lost this case. So the Supreme Court further expanded the Commerce Clause authority to include things that were purely manufactured and used within a state that had no bearing whatsoever on interstate commerce. Then the next one, this fairly recent case, NFIB versus Sebelius, it held that the Patient Protection and Affordable Care Act was constitutional because the issue in the case was the individual mandate, and as I mentioned earlier in this meeting, the majority held that the individual mandate was not authorized by the Commerce or Necessary and Proper clauses, but that it was a lawful tax, even though it was a tax on not doing something. And moreover, that it was an indirect tax not subject to apportionment. So how it could be an indirect tax that could be passed on to someone else as the increased cost of a commercial transaction, how do you pass on a tax to someone in a subsequent sale when what it is that is being taxed is doing nothing? So that exhausts the list that I composed for today's meeting. I could have included others, but it shows a pattern in which, in each case, there were political pressures on the side of increasing government power, and only weak pressures opposing it. And the court, although it provided a rationalization for its decision in the way it reached an opinion, was essentially yielding to those greater political pressures. So although we can blame the courts for yielding, the simple fact is that we, the people, did not have our ducks lined up at any point along that process. we did not have enough political pressure pushing in the other direction. And that's what it's going to take to get us back to constitutional compliance. Thank you for attending this evening.